Court, all rise.
Morning, everybody.
Morning. Hampshire County Superior Court is now in session. Please be seated.
Good morning. Now before the court is Hampshire County Civil Action 1780 CD 0033, Patrick Buchanan et al. Versus Town of Greenfield et al. For continuation of the jury trial.
Good morning, ladies and gentlemen. Has anything come to your attention in the overnight hours since I've last seen you here in court, which has affected your abilities to remain fair, to remain impartial? All right, no affirmative responses. I understand one of the jurors would just like to have later on this afternoon, if you're still deliberating, an opportunity to take a brief break to handle some personal matters and just let the court officer know that you wish to do so, and we're more than happy to accommodate you. Okay? You may return to your deliberations. Thank you very much.
All right.
Three exiting.
All right. Counsel, in that regard, it was juror number 46 who advised the clerk that she needs to sign up on some documentation that her husband's going to bring to the courthouse at 3 o'clock, and certainly I'll give her an opportunity to do that. Shouldn't take long. Attorney Keston, there's something that you wish to discuss, I understand.
Yes, sir. First, Your Honor, it's been 9 days since my close contact, so can I take the mask off?
Yeah, let me take a look. I think it's 10 days.
Okay.
It's 10 days, so sorry. Go ahead.
Oh, no problem. Your Honor, I woke up at 2 in the morning and realized that the jury verdict slip is fatally flawed.
Okay, and how is that?
The special questions are designed to allow the court to enter a judgment for or against somebody. Question 1 is passive. It doesn't say who. That's the question that you inserted yesterday at the plaintiff's request.
Okay, so have you discussed this yet with counsel?
No.
Why don't you take a moment so that they understand what the issue is, so that they can formulate their response, and then I'll come out and I'll hear from both.
Court, all rise, please.
All right.
Your court's back in session. Please be seated.
So, Attorney Keston, is the concern that questions 1, 2, 3...
Not 3, Your Honor.
One moment. Right, okay. So that question 2, which was effectively your proposed question, except the word so-called.
And 1.
And 1, I understand 1. I think it's just then 1 and 2. Doesn't specify.
And 6.
Okay. Okay. And 6, I believe, was also your proposed question.
Regardless.
I understand that. But I think what you're about to say is that it doesn't delineate whether or not it was by that such discrimination was at the hand, so to speak, of the city or the chief.
And further, when we talk about the city, the jury's who?
Well, the city, it's the city of Greenfield is the defendant. Is that your concern? Because if that's what it is, that is easily addressed. But having said that, these were your proposed special jury verdicts. But if the question, which I think is with point, is well taken, that those particular questions do not ascribe liability to individual defendants as opposed to just in general. So it's not so much being cast in a passive sense that they don't specify which defendant is liable. Then that's something that we should discuss. Is that your point?
Yes, and yes, that's absolutely the primary point. The secondary point is when you say the city. So if the chief didn't do it, right? So I would, if they say it's not the chief, but it's somebody else, the city, who? Well, you see, here's the problem. The problem arose in large part when Mr. Ryan argued about the gang.
The what?
The gang. He said the gang did it. The posse, the midnight posse did it. The midnight posse came out. He kept referring to plural people that did it.
That did what? That did what?
Discriminated. I'll get the tape. I mean, that's how he argued it, not that Chief Haig did it. He was arguing that there was a midnight posse that did it.
I think that was in the context of in a different context. In any event.
No, Your Honor. It was in the context of they brought out the midnight. Then he said that our version of the midnight posse was false. But he kept saying the plural. They did it. They rose. They did it again. He mentioned McCarthy by name.
Okay.
So if the jury has to decide who, it can't just be the city. If they decide, for example, that McCarthy did it because he implied that McCarthy had animus, because he did the whatever, then the city's not liable.
Okay. I
But the
understand
jury
what you're
doesn't
saying.
know. And Your Honor, the last part of the damages question,
Which one?
question 7.
Yes.
I don't think it's particularly comprehensible what that means. Any damages you award are limited to one amount for such time period.
Oh, okay.
I don't quite know what that means.
Okay, very well.
And if he, on these facts, if he should have been promoted, let's say, on 14, that's one set of damages. If in 2015 the jury finds that the chief's 3-day suspension.
Right, we've discussed this multiple
Well,
times.
I'd just like to put it on the record.
Okay. Again,
This
go
is
ahead.
why I asked for special instructions on damages for each. If the damages for his suspension in 2015, all he would get is emotional distress, nothing else. And the jury has not been told that. Your response to me was argue it.
Correct. Okay.
And I do have also something on the jury instruction.
Okay, we'll deal with that separately. All right, who wishes to be heard first over here?
Your Honor, I do.
First is to questions 1, 2, and 6.
Yes, Your Honor. Chief Haig wasn't added as a defendant until after the 2021.
Well, the jury doesn't know that.
Yeah, but after the 2021 promotion. It's always been against the town.
Well, that's fine, but I think the point is well taken that in terms of what a judgment looks like, there are the judgment needs to reflect who the defendant is for the respective counts. Okay, so that taking what you just stated, then as to question 1,
It would be the town.
pardon me,
It would be the town, Your Honor.
the city.
Before the city.
Okay, so bear with me a brief moment.
And the same for 2.
Okay, I'm not quite there yet. Bear with me a moment. So that question number 1 would read: Did the plaintiff Patrick Buchanan prove by a preponderance of the evidence that the city of Greenfield discriminated against him because of his race, etc.? Is that correct?
Yes, Your Honor.
Okay, Attorney Keston, is that what you're seeking for question number 1?
Absolutely not.
Okay, what are you seeking?
You gotta tell these. We have to have something that is just who. The city can't be liable. The city will be liable through action. So if it was McCarthy, let's say, if they decide McCarthy had something to do with it, right? The city would not be liable.
Okay.
But as far, the way it is now, they have no idea who the city is. The city is not a amorphous body.
Your response.
Your Honor, the city is the actor. The municipal corporation is the actor, and it acted by and through the acts of multiple agents. And collectively, the city is responsible legally for the various acts of its multiple agents.
Okay.
That's not true. Your Honor, that is not the law. That is not the law. This is not respondeat superior. This is not a negligence case.
Okay, I'm going to leave it as the city of Greenfield. All right, now question number 2. Okay, so Attorney Ryan, what is your proposal for question 2 then?
It would be the same thing, Your Honor, that by preponderance of the evidence that the city of Greenfield failed to promote him from the shortlist.
Okay, and Attorney Keston, you have the same objection, I take it.
It's an absurd request.
Okay. It's going to be the city failed to promote him. Okay. So that takes care of questions 1 and 2. 3 and 4 identify the chief. And it really should say Chief Haig. All right, now 6. Okay, as to 6 then, Attorney Ryan.
Your Honor, I would, for simplicity's sake, just ask that it continue to be the city of Greenfield solely.
All right, you just said that Chief Hague came in 2020, 2021. How do you square that with what you just stated to me?
I think just for simplicity's sake, Your Honor, it should be the city of Greenfield. He's an agent of the city. Or no, actually, Your Honor, that the city of Greenfield and or Chief Hague.
They would have to be separate questions.
Okay.
So one question would have to be, if indeed, as I understood, your argument was that liability for that time period was alleged against the city and Chief Hague, there would need to be 2 separate questions, one for the city, one for Chief Hague.
No objection, Your Honor.
Okay. And Attorney Keston, I take it you have the same objection relative to the characterization of the city of Greenfield.
I want to highly stress again that this jury has no idea who would make the city liable.
Okay.
The city is not an amorphous mass. So when he says that they're agents not for 151B, there's no such thing. There has to be some individual who would bind the city. By you just simply telling them that they make a finding that the city was liable, that tells us nothing. Because they have no idea how the city, who would be liable. Mm-hmm. Again, if it's McCarthy, the city's not liable. If it's, is he saying gaming again? I just heard him say he's gaming him again.
I did not hear that.
I know what I said.
Well, council can discuss that outside of the courtroom if you wish. All right, I understand your point. Anything further in that regard, Attorney Ryan?
No, Your Honor.
Okay, it's going to remain the city of Greenfield. That is what has been alleged. That is what has been argued. And if the jury has questions in that regard, they can pose the questions. Now, as to Attorney Keston's point that he does not think that the language set forth in question 7 is clear. Any damages you award relating to the period September 2014 through October 2015 as set forth in questions 1, 2, 3, and 4 are limited to one amount for such time period. In my mind, that is clear. Attorney Ryan, your thoughts, please.
Your Honor, I agree it's clear. I mean, it's lost back wages and it tells them it's just for that time period.
Okay. It's going to remain as it is. All right, now.
What does that mean?
It means exactly.
I'm totally confused.
It means exactly.
14 to 15?
It means exactly what it states. All right. As to the jury charge, what is your concern, please?
You added to the whistleblower on page 24.
One moment, please. Okay. Yes.
You added in the last sentence of the first paragraph, for the purpose of this case, if Mr. Dodge reasonably believed that the conduct violated chapter, general law chapter.
One moment, please. Okay, go ahead.
151B, the anti-extradition statute, and general laws chapter 31, the civil service statute.
Right. That was at Attorney McDonough's request. You objected, and I permitted Attorney McDonough's request to add that. Indeed, that had been argued. And there was evidence in that regard. And so I addressed that matter at sidebar.
Well, I have another point.
Okay, what is that?
The jury has no idea what Chapter 151B is. No, it has zero idea of what Chapter 31 is and what it forbids. Nothing. They've been told nothing about what that chapter actually forbids. Mm-hmm. So how are they going to decide if we reasonably believe it?
Okay. Attorney McDonough, your response.
First, this has been waived. We've already addressed this. This, I guess, is a motion to reconsider. My client testified on the stand. Those are the two laws he reasonably perceived that the town and the defendant was violating. Those two, he named those laws.
There has been testimony that Lieutenant Dodge believed that there were violations of those two statutes. I've already ruled on this particular matter. Okay.
Then how are they going to say if it's reasonable if they don't know what the statute forbids?
The testimony there's sufficient testimony before this jury for them to rule on that matter. Your objection is overruled.
There is no testimony as to what Chapter 31 even is, what it forbids. It does not forbid discrimination. And there's testimony by him that he believed they violated it, but then the jury has to weigh whether it's reasonable. And the only way they can do that is if you explain the statute to them.
Okay, I'll give you the final word here, Attorney McDonough.
It's just incorrect. The court correctly ruled on this. There's been plenty of testimony on this. There's no need for a change now. And certainly, it was waived by counsel.
Okay, I agree. I'm going to make the revisions to this special verdict slip that we just discussed, and will be sent out to you momentarily. Thank you.
Board, all rise, please. Court will stand in recess. All rise, please. All right, welcome back, everybody. Your board's back in session. Be seated.
All right, ladies and gentlemen, sorry to interrupt your deliberations. I just wanted to give you what is a revised special jury verdict slip. So we're going to take the one that you currently have. Okay, let me just ask Madam Poor Lady, have you written anything on it? Okay, great, thank you. That will be marked then as E for identification. Now we're
Your Honor.
Thank you. That's fine. Great, thank you. This is a new one?
Yes.
Okay. I've got a copy here. We've made some minor revisions. And so let me just identify what they are so that when you get it, you'll be able to flag them. As to questions 1 and 2, there's a specification that the city of Greenfield, in question 1, discriminated, and in question 2, failed to promote. Okay? In reference to chief is just simply amended to say Chief Haig. And in question 6 has now become 2 separate questions. That was the question relative to the 2021 Sergeant promotional process. New question 6 relates to the city of Greenfield. New question 7 relates to Chief Haig. And then the follow-up instructions have been amended accordingly. Those are the only changes. Okay? You can return now to your deliberations. You'll have the new special verdict slip with you. Okay? All right. Thank you.
All rise.
Okay. Thank you.
Have you
Court
heard?
will stand in recess.
Yes. Let's wait till the jury leaves. Attorney Keston.
Your Honor, there is no respondeat superior under 151B. There is only respondeat under 151B. The employer, in this case the city of Greenfield, can only be liable through the actions of supervisors. The way this jury has no way to know whose actions would make the city liable. And it's wholly improper. How are they going to decide who's, if it's not Chief Haig, who is it?
Okay.
And Mr. Ryan has argued that they're all their agents. That's not true. There has to be somebody. And
Can I see your proposed special verdict slip, please? No. Defendants.
Oh, I don't disagree with you that I was wrong.
I'd like to see it.
Which, okay, I don't know if we have left most of our stuff in the, I'll look.
The special verdict slip that defendants proposed and presented to the court identified the defendants did not request a delineation of specific actors on behalf of the city of Greenfield. Moreover, despite the discussion, multiple discussions that is, relative to ascribing damages to separate incidences, I have yet to see anything from the defendants that does so. Counsel has argued it, and has argued it after the special verdict slip was sent in to the jury. But I have not seen any draft from the defendants that presents that sets forth that sort of a delineation of damages. So I'd like to take a look at defendant's special verdict slip. If you don't have it, then we'll take a moment and we'll get it from our files. And while we're doing that, I would like a further. And this is, I've already heard this argument, but I'd like to hear further argument from counsel. So, what I'm going to do is going to take a look at Chapter 151B myself. I'm going to get your special verdict slip that you requested. I'm going to step off and further I'm going to ask counsel to provide me with the legal support for your argument. Okay?
All rise, please.
All right, we have a question from the jury. What do we have to G?
County Superior Court Fact and Special, please be seated.
All right, which will be marked as G for identification. And it says, should we as a jury focus on one question at a time? For example, should we answer question 1 and then follow the instructions based on the answer? That's one question. The other question, is any other person allowed to read the verdict slip other than the foreperson? And I believe the answer to both of these, which I propose to send to them in writing, is yes. Okay? Should we as a jury focus on one question at a time? Yes. Okay? And is any other person allowed to read the verdict slip other than the foreperson? Yes. Okay? Any objection?
No, Your Honor, we agree.
No objection.
Any objection, Attorney Keston?
No, sir.
Okay. So, let me write this out. Okay. This we marked as H for ID. In response to your question, marked G for ID. I reply as follows, : question, should we as a jury focus on one question at a time? Answer, yes. Question, is any other person allowed to read the verdict slip other than the foreperson? Answer, yes, signed by myself. Okay? So we'll go to them. I'm still researching the issue that we discussed. I have not yet received the Westlaw cases. I've reviewed all the other cases. So as soon as I get them, and as soon as opposing counsel have an opportunity to review those cases, I'd be happy to hear from you. All right, we're back on the record. Thank you for the case citations, which I have now reviewed. All right, Attorney Keston or Attorney Brody, do you wish to be heard further before I turn to Attorney Ryan and Attorney McDonough?
On this issue, no, Your Honor, I think we've made the point.
All right, thank you. Attorney Ryan.
Your Honor, I'm not even sure what the point is. But I submit it's been waived.
Well, why don't you articulate your understanding of what it is that you are objecting to or opposing so we have a clear record?
Your Honor, for the life of me, I don't understand what their objection is.
I believe the issue that has been raised relates to the defendant's now request to identify an actor, so to speak, on behalf of the city of Greenfield, and there's been a representation that that respondeat superior does not apply in discrimination cases. That was the issue that I was sent off to research, and which I have researched. I'll say that none of the cases that I have now reviewed stand for that proposition, nor am I aware of any case in which the doctrine of respondeat superior does not inure to municipal actors such as the city of Greenfield. That, to at least put it in the frame in which I understand the question, is what I understand is on the table. So, to that end, your response, please.
Your Honor, so one, I believe it's been waived. It's long past the time. It's not in their first proposed jury verdict slip. It's not in their amended proposed jury verdict slip. Further, Your Honor, if we look at 151B, Section 4, Paren 1, or the Clause 1, it's an unlawful practice for an employer by himself or his agent. So it's the employer, Your Honor. And the definition of employer in Section 1, and I forget what the clause is, identifies employers to include the Commonwealth in all political subdivisions. Further, Your Honor, I would cite to you the Haddad case, which is 455 Mass 91. It's an 09 decision. That was a case just against Walmart. There was no independent, there was no officer. Another case, Your Honor, I would cite to your attention is Brownlee versus Kanzaki. That's 44 Mass Appeals 408. It's a 1998 decision. That's an age case. Haddad was a gender discrimination case. But in both of those cases, Your Honor, there was no actor, there was no agent. It was just the corporate employer. In that case, in our case, we have a municipal corporation.
Okay, thank you. Attorney McDonough, do you wish to be heard?
No, Your Honor.
Okay, for the reasons that have been substantially articulated by Attorney Ryan, the request to modify the special verdict slip relative to the identification of the city of Greenfield is denied. Okay, we'll stand in further recess. Thank you. Right, I have defendant's third motion for mistrial under, I believe it's Fitzpatrick or Fitzgerald. I'm required to address these as they arise. So the motion itself is twofold. There are matters that have been already argued before me. The first relates to the jury charge and the jury verdict slip. And in particular, defense counsel maintains that there is certain strict liability for employers in discriminatory acts of its supervisors, and that in the context of the city of Greenfield, that the jury charge is not clear as to who the employee or supervisor, so to speak, would be, who is the responsible party for the city of Greenfield. And in particular notes that there had been argument, as there was, relative to Sergeant McCarthy, although I'll admit it was a bit confused in any event. So the request is for a mistrial on the basis of the language of the jury charge in particular, and then there is further request relative to the issue pertaining to a reference to Chapter 151B, which the jurors have been instructed on, as well as Chapter 31, which is a civil service law. And in that latter regard, there was testimony, at least as to Lieutenant Dodge's understanding as to the civil service law, and certainly there was plenty of testimony from others as to what the provisions of that chapter entailed in a practical sense in this case. As to the issue of the jury charge. I've given to each counsel what I have captioned as a proposed further instruction to the jury. And what I am contemplating doing is further instructing the jury and then giving them a copy of this document, which would be marked as, I believe, H for identification,
Aye, Your Honor.
I for ID, the following. And this language is taken directly from the defendant's third motion for mistrial. An employer is strictly liable for the discriminatory acts of its supervisors. An employer is only liable for the discriminatory conduct of its employees where the employer knew or should have known of the conduct and failed to take adequate remedial action. If you find Chief Hague is not liable for the discriminatory conduct Patrick Buchanan alleges, then you are limited to determining if the city of Greenfield, by and through the actions of then Mayor Martin, is liable for the discriminatory conduct Patrick Buchanan alleges. Okay, Attorney Keston.
Yes, sir. This is not going to cure it.
What is your proposal? You know, one of the difficulties that you presented is that I have no proposed language from you. What is your precise proposed language? And if you want to take a moment to write it down,
No.
So then please tell me what it is so I can write it down.
We're in a situation now where they could have answered some of these questions already. And write it down. I'm happy to give you at least something that would cure it. But let me tell you
We're going to take a break then, and you're to do that. No, you're to do that.
Yes.
And I will consider it because you keep making requests that I act with no proposal made, and that proposal has to come from you.
Okay.
So we'll stand in recess. You're to write out that proposal, handwrite it out. It'll be faster, okay? Share it with counsel, and then I'll review it, okay?
I think it'll be faster if I type it and email it.
Well, whatever you want to do. I'd like to get
If you want me to handwrite, I'll do it. My handwriting is terrible.
Well, have Attorney Brody do it. I presume her handwriting might be neater. Okay, very well. But this is what I'm tempted for, and I want to get this to the jury. I'll bring it in. I'll read it to them. They'll get it, or some version thereof as soon as possible. But I need it.
Okay.
You can't go forward in this matter without questions 1 and 2. You've been asked to determine whether the city of Greenfield discriminated against Patrick Buchanan. In question 6, you've been asked to determine whether the city of Greenfield discriminated or retaliated against Patrick Buchanan. I think that is correct. Okay. I instruct you that in order to determine whether the city was liable, the person or persons who discriminated or retaliated must be supervisors. Okay? That is a correct statement of the law. Is there any disagreement in that regard?
Yes, sure. I have a big disagreement with all of this, but.
Well, that's not my question. My question
Yes.
is to that woman's sentence.
Yes, sure.
Okay, what is the basis of your objection that the person who discriminated or retaliated must be supervisors if I've eliminated the attributable bias?
Because you've eliminated the attributable bias. Exactly, Your Honor. You've taken out the attributable bias, and you've given them this. So you've taken out the attributable bias, which we requested, and now you're putting in that there's got to be strict and specific liability.
Well, first, they requested that I remove the attributable bias.
Yes.
You just said we requested.
No,
Go ahead.
I apologize, Your Honor. But the attributable bias instruction is out of the case. And so we don't have that instruction in this kind of, is again, contrary to attributable bias, saying you've got to find specifically, it's contrary, Your Honor, to the Brownlee. It's contrary to Haddad, in which it was just cases against the employer. And not here. I further submit, Your Honor, that Abashi, and I have a copy for both of you, has to do with a claim under 4A. Section 4A, not under Section 1. So this is the employee of a subcontractor in the...
I saw that, and this is not a 4A case, I respect that.
But that's the case law they cited to you.
Is in Haddad, okay, who was the individual who was the employee or supervisor, whatever have you, of the municipality? Who was it?
In Haddad, Your Honor, it was the corporation. They identified the corporation.
But there were facts that set forth that people acted with discriminatory animus as agents, servants, employees of the corporate entity. Is that correct?
In Haddad, Your Honor, they focused on the corporate entity, not specific individuals.
Okay, I'll take a look at Haddad. What's the site again?
Your Honor, it's 445, I believe, Mass. It's in my papers here.
Of course, it's the one that is missing.
Your Honor, it's 455, excuse me. 455-91.
One moment. So this is a case alleging unequal compensation and termination of employment based on gender, okay?
Sure.
One moment, please. Give me a second. Okay, and so without delving into this, there's discussion relative to the actions of a manager at Walmart. That's what I'm getting at. Okay, let me move on to the rest of this. And this proposed instruction only relates to Patrick Buchanan. Okay, yes, Attorney McDonough.
My claim is derivative, Your Honor, and
I'll hear from you. Let me finish this, though, okay? All right. I take it, Attorney Brody or Attorney Keston, that the first paragraph is based upon College Town.
Honestly, I mean, it's based on the law as I know it.
Well, it's my reading of College Town.
Yeah, I mean, it's black letter law.
Right.
Well, I mean, wherever it comes from, I know College Town is the seminal case, Your Honor, but I can't tell off the top of my head, but this is... Anybody that does discrimination knows this.
I instruct you, in this case, I instruct you that Chief Haig and Mayor Martin were the supervisors of Plaintiff Buchanan. So, it seems to me that the only two supervisors who are at issue in this case are Chief Haig and Mayor Martin, okay? Attorney Ryan, your thoughts in that regard?
Your Honor, without the attributional bias instruction, this, it moves it so strongly in their direction. And the court has made clear, they never asked for this, the court has made clear the attributional bias instruction doesn't come in, and so now we get an extra instruction in their favor, and we don't get the attributional bias instruction.
It's not the way it works. I deny the attributable bias instruction in light of the Millay case. I'm satisfied that the supervisors here were Mayor Martin and Patrick Buchanan and Chief Haig. And I'm going to hear from you in a brief moment. Let me just go through this first, Attorney McDonough. I instruct you that the City of Greenfield can only be liable to Patrick Buchanan if in this case, if one or both of those individuals acted with discriminatory animus, the two supervisors. You've heard some evidence and argument about then Sergeant Daniel McCarthy and other employees of the city. I instruct you that the city cannot be liable for actions of Sergeant McCarthy or for any other employees of the City of Greenfield. Anything further you wish to say, Attorney Ryan, before I turn to Attorney McDonough?
Yes, Your Honor. The whole thing about Sergeant McCarthy It was to respond to evidence and arguments put in by my brother as to the IAs. We did not say he was a decision maker, Your Honor. We put in the fact that there were 5 IAs predating January 2015 by McCarthy, and they included the gum and they included the other things. We stayed away from where the court said we had to stay away from. So to highlight McCarthy yet again, in light of taking out the Confederate flag, in light of the fact that we don't have an attributional bias instruction, in putting this all in, it works severe prejudice to us. All of these things were agreed to. There was an objection at the time you sent the jury out. And so, this is continue to, incremental changing the instructions that everyone agreed to. And they had not asked for this, Judge. This is nowhere. This appeared at 2:30 for the first time. It didn't show up before. This case is 10, 11 days old. Mm-hmm. And so it's extremely prejudicial. They waived it, and to bring it in now and to throw in all the McCarthy stuff is extremely prejudicial to the plaintiff's case.
All right, thank you. Attorney McDonough, listening.
Your Honor, it's the standard's grievous error here. There's no error whatsoever. And this is just the 4th or 5th time this is being re-argued, this issue. Now with a new instruction that's going to go in special as a separate message to the jury after. There's a reason why they all go in as one charge together. There's some things that are favorable. One side, some of the other. It goes in together. And there's a reason why we do that special sidebar with one last chance for objections is because it's going to the jury. We argued on those instructions. We relied on those instructions. We haven't submitted to you 4, 5, 6 motions for mistrial about attributional bias. I disagree with some of the arguments my brother made. He claimed in his argument, Your Honor, that there was no whistleblowing activity whatsoever. Can I have an instruction listing out my rebuttal to his argument and putting in all the little things that I say are wrong about that? This is just extra argument, and you're just inviting more and more and more and more opportunities to just go change the charges after counsel sat on their rights and didn't request this. This is not part of the standard instructions for a reason. It's not required. If counsel wanted this, we went over the charge several times in this case over multiple different days. And it is completely unfair and prejudicial to put a pro-defense message like this to the jury so late in the game. It's separate from the package charge. And absolutely, that last paragraph is simply a rebuttal argument by defense counsel. There was no argument ever by either of us that McCarthy was a supervisor. And it's just, the answer should just be motion denied. There is no grievous error, let alone legal error. And that's it. We've gone over this and counsel waived their rights.
Thank you. Anything further?
No.
Okay. All right. I've never seen a case, never had a case in which there were so many requests for further instructions after the jury's been sent off. That doesn't mean that it can't happen, though. If it is otherwise permissible, then it would be in order. What is before me is a motion for mistrial, which I'm required to rule on right now. I can't wait, okay? And I'm required to address the issues that are raised. And the issue relative to the proposed instruction, I find to be a legitimate issue. It should have been raised before. That's the bottom line. All of these issues should have been raised before. As a judge, I take in what is proposed. I take in proposed jury instructions. I take in proposed special verdict slips. And if they appear to me to be appropriate and in line with the law, then I send them in. When counsel then comes forward with corrections, whatever, I can't just say, no, you've waived it. I have to actually consider it. And in this regard, the proposed instruction is an accurate statement of the law. It does serve to clarify the answers to questions 1, 2, and 6. And it is an accurate statement of the evidence before this jury in terms of who were the supervisors and who were not the supervisors. And Sergeant McCarthy was not a supervisor, okay? The last paragraph of this instruction is a correct statement of the law as it pertains to Sergeant McCarthy as well. So I'm going to allow this. What we're going to do is we're going to bring the jury in. I'm going to read this to them. I'm going to mark it for ID purposes, and they're going to get it. Okay, the motion for mistrial in all other regards is denied, mindful of this further instruction. mindful that as a general matter, motions for mistrial during a civil trial should be denied, allowing the trial to continue to verdict, and mindful that counsel have the option of the motion for new trial, and finding that otherwise there's been no grievous area, the motion is denied. So I'm going to step off, and I'm going to correct this proposed instruction to take out the word proposed and replace it with the word further. I'm going to bring in the jury right now, and I'm going to address this matter with them.
Your Honor, we may be heard. We were not permitted to submit our written version, and the prior version from the court said that the defendants are strictly liable if any supervisor committed anything discriminatory and animus.
I'm sorry, you weren't permitted to submit what prior version of what?
Of this instruction. We've had the court's version and the defendant's version, and now this one is rewritten from strict liability to it's placed in the negative. I instruct you that if either one of them doesn't have discriminatory animus, you cannot find the defendant's liable. And I just don't understand why they would get to rewrite the court's version.
Okay.
The line about
Without surprise, one moment, please.
Yes.
Okay. Where are you referring to?
This was what the judge had said. Right. So we've gone from an employer is strictly...
What sentence in particular are you referring to?
Paragraph 2, final sentence of paragraph 2.
I instruct you that the city can only be liable to Patrick Buchanan in this case if one or both of those individuals acted with discriminatory animus. Okay, so there's no negative in there.
It's the inverse of your original proposed instruction, sentence 1. An employer is strictly liable for the discriminatory acts of its supervisors.
Oh, the one that I took from there.
Right.
Okay, hold on a second. Okay, let's take a look, because this was taken from their brief. An employer is only liable for the discriminatory conduct of employees where the employer knew or should have known of the conduct. Okay, an employer is strictly liable for the discriminatory acts of its supervisors?
Correct, Your Honor.
So what's the problem here?
That's a better statement of the law. And the defendants get to rewrite your statement, which was an accurate statement of the law, in the negative.
Well, it was their statement. I actually cut and pasted it from their motion.
We object to both of their statements, but that one is at least more neutral, Your Honor, the first one.
Okay, one moment, please. I'm satisfied with the one as submitted in the proposed instruction. So I'm going to go and make this one correction.
May I be heard? This goes back to the attributional bias, Your Honor.
It's done. I've ruled on that 18
but
times.
Your Honor, you've ruled on the instructions. You've ruled on the instructions.
I'll hear from you, and then I'm going to go off and make this correction and bring the jury
And
in.
Your Honor, with respect to that, remember, it's the chief who is not the decision maker. It's the mayor. And the chief said in October 2014, he's lazy, doesn't fit the bill. If I don't have an attributional bias instruction, and I've got to show that the mayor was acting based on discrimination as opposed to bias.
This argument has been made many times over. I've ruled. Thank you very much. Right. Ms. Doran, if you can favor just email this to me.
I just did.
Okay, I'm coming right back out, so just bring him in, okay?
What's he talking?
I know, it's unbelievable.
Jury answer? Please be seated. Court, all rise, please. Mr. Connor, Superior Court is back in session. Please be seated.
First, welcome back, ladies and gentlemen. I'm going to offer you a further instruction that is being marked as I for identification, and which you will have with you. I'm going to read it into the record. In this case, in questions 1 and 2, you've been asked to determine whether the City of Greenfield discriminated against Patrick Buchanan. In question 6, you've been asked to determine whether the City of Greenfield discriminated or retaliated against Patrick Buchanan. I instruct you that in order to determine whether the city was liable, the person or persons who discriminated or retaliated must be supervisors. In this case, I instruct you that Chief Haig and Mayor Martin were the supervisors of Plaintiff Buchanan. I instruct you that the City of Greenfield can only be liable to Patrick Buchanan in this case if one or both of those individuals acted with discriminatory animus. You've heard some evidence and argument about then Sergeant Daniel McCarthy and other employees of the city. I instruct you that the city cannot be liable for actions of Sergeant McCarthy or any other employees of the City of Greenfield. So you'll have that with you. Now, I believe one of our jurors needs to take a break at 3 o'clock. It's just about 3 o'clock. If that is still the case, please nod your head yes. Okay. Okay, and it's for 3 o'clock, right? Okay, let's do this. If that juror would please let the court officer know when you need to take, I understood it would be a brief break, okay? And you can then go down to, I understood, someplace close by here in the building, mindful that you cannot discuss with anyone your deliberations or any matter pertaining to this case, and return right back. The jury is to absolutely cease its discussions and deliberations during that time period. Okay, that's an absolute prohibition. Okay, thank you very much. You'll have I4ID with you, and if you are still deliberating, I'll send you a note just around 5-10 after 4, as I did yesterday. Okay, thank you all.
All rise, please.
Okay, thank you all.
No sure enter. All rise.
Good afternoon, everybody.
Good afternoon, Your Honor.
Welcome back, ladies and gentlemen.
Superior Court's back in session. Please be seated.
Okay, I'm going to suspend your deliberations until tomorrow morning at 9 o'clock with the ongoing instruction not to discuss the case with anyone, including amongst yourselves, friends, family members, anyone in any medium whatsoever, nor to do any investigation or research or look at any media reports. I look forward to greeting you tomorrow morning at 9 o'clock. Thanks and have a great evening.